Welcome back to the Florida Rights Institute informational video series. This video is covering Florida vehicle marijuana smell and probable cause issues. It'll be an overview of whether marijuana smell alone is sufficient for a vehicle search. Please remember that the following presentation is meant for informational purposes only and is not intended as legal advice. Seek a licensed attorney if you need legal assistance. Floridians have a right to be free from state intrusion generally. Florida Constitution Article 1, Section 12 states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and against the unreasonable interception of private communications by any means shall not be violated. Florida Constitution Article 1, Section 23 notes a right of privacy as well. Every natural person has the right to be let alone and free from governmental intrusion into the person's private life, except as otherwise provided herein. Marijuana's legal status. According to 21 U.S. Code Section 844, it's a federal crime for possession of marijuana. Florida Statute 893.13 states that it's illegal to possess marijuana generally. And Florida Statute 1381.986 states that there is a medical use exception in the state of Florida. A new legal challenge arose with the 2018 Farm Bill under federal law. The definition of importance is in 7 U.S.C. Chapter 38, Subchapter 7, Section 1639O. This section notes how the bill only banned Delta-9 THC cannabis because hemp was legalized as long as it contained less than 0.3% Delta-9. This opened the door for different carbon bond variations of cannabis to be sold, such as Delta-8, Delta-10, and THC-0. It also allowed for smokable hemp. With these new products, the smell of marijuana alone no longer immediately implied criminal behavior. The smell test issue. Generally, the smell between Delta-9 and other smokable hemp products is not readily distinguished by humans or drug dogs. This means that an officer, and even an officer with a canine unit, cannot tell from smell alone whether someone has been using a legal or illegal product. With their smell, they might be able to claim that someone either is smoking, may have just smoked, or has been around others smoking, and this created a tricky legal situation. Initially, prosecutors warned that smell alone was not enough. Prosecutor offices across Florida initially sent out memos that smell alone may no longer be enough to prosecute with the new Farm Bill's passage. They warned that distinguishing between hemp and cannabis by sight and smell is virtually impossible and requires special lab testing to confirm. Presumptive tests were no longer sufficient. This caused a change in how police gathered evidence until appellate courts started to rule differently. The big challenge on the Florida legal side is Owens v. State. The Second District Court of Appeal ruled that the odor of burnt marijuana in a car indicates the illegal use of marijuana. They adopted the opinion of the Ninth Judicial Circuit of Florida in State v. Ruise 2020 that held probable cause is grounded by smell if a person is in a vehicle. They claimed that the smell was probable cause to assume the person is under the influence because it was burnt, as in recently used. They also said that being a medical marijuana user might be an affirmative defense, placing the burden on the defendant if they were just in possession and had fresh marijuana. But then a possible counter-challenge from another circuit came along. The First District Court of Appeal in Hatcher v. State, July 6, 2022, entertained a case of a driver being stopped and an officer claiming that the driver's laid-back stance and car's smell of burnt marijuana led to searching the car. The officer had a canine alert as well, and they searched the vehicle, finding MDMA and marijuana. The court decided not to rest on the burnt smell of marijuana issue alone because there are other factors in the totality of the circumstances, including the driver's demeanor of seeming under the influence, the driver admitting to not having a license, and the driver admitting to having thrown a blunt out the window, assumed to be cannabis. The concurrence is where we find a hint of the First Circuit going against the burnt smell alone being sufficient as against the rulings of the Second and Ninth Circuits. Justice Bilbrey stated that an officer seeing something that could potentially be either legal or illegal does not give rise to reasonable suspicion to stop someone on its own without more information about criminality. As an officer cannot distinguish between legal hemp and illegal cannabis without a test, they should not be able to stop someone solely for the smell without more details that would confirm illegal use. Bilbrey made an analogy to the concealed carry of firearms not being sufficient to ground reasonable suspicion because it could be legal. This is a problem that must be challenged. Some courts are making a mistake because they wrongly assume that the act of smoking is the act of getting high. If the smoke comes from non-psychoactive product, then it would not get someone high and would be no different than someone legally smoking a cigarette while driving. The Owens case did note that the stop involves someone driving recklessly, so it may require a case where someone is wrongly pulled over or pulled over while smoking a non-psychoactive version to be challenged with the best set of facts. As it stands, people in Florida now do stand a risk of having their car searched if an officer smells smoked cannabis or hemp product, especially if it's a recently burned smell. There is a possible conflict looming from the concurrence of the First District Court in Hatcher v. State. We'll have to wait for a conflict case to make it to the Florida Supreme Court to find out whether smell will be sufficient alone for a vehicle search or insufficient throughout the entire state. Until then, the rulings at the respective appellate courts will stand. Thank you so much for watching this educational video. For more informational educational videos, please subscribe to this channel and visit floridarights.org.